languages which would relate what privacy is all about. It's a very interesting thought to ponder on for all of us. Is privacy something which is very new, or is it something which was always there with us culturally as a civilization? Or is it something which has been imported to us along with several other things over a period of time with the intermingling of civilizations by different modes of their entry into India? Now, going forward on this issue, I would like to draw your attention that there is a concept in Indian thought which is called Manasa, Vacha, Karmena. We need to be acting in accordance with our dharma. Manasa vis-a-vis reflects the thought process, the thinking that we entertain in our mind, and we cultivate and develop those thoughts. Vacha refers to the words that we use while we correspond with others in writing or orally. Karmena is that where we use our karmendriyas to act upon those thoughts, words, which convert into action. It is also popularly said that we please watch your thoughts because they become your words and then they become your actions and then they actually determine who you are. So therefore, it is important that we actually understand that thoughts are the source of our personality because they reflect into words and then they reflect into our actions if we keep pursuing them. Now, with this in mind, I'll request my colleague Ushasri to start the presentation. I created a 12 slide PPT for the convenience of presentation in this digital platform. Usha, if you could just start the screen share, please. Yes. Yeah. Can we go to the first slide, Usha? Yeah. The next one, please. Yeah. Okay. I can just adjust the screen size. Just can you make it a little smaller? Yeah. And can you just yeah. Okay. Or could you do it in a slide mode where only one slide is visible? Just a minute. I think as Usha would be just setting up the slideshow. The first sloka that you see, I can just summarize it for you. I mean, it is in Sanskrit, and then the second paragraph in the other color is the transliteration, so that someone who's not familiar with Devanagari will be able to pronounce this sloka as it's spoken in Sanskrit. I'm not literate in Sanskrit, but I'm a very enthusiastic about the language, and then I try to read and understand by using translations. Now, if you see, the privacy context will have to be seen between the person whose privacy is in question and the world at large. Therefore, privacy qua whom? Can we be having some kind of a privacy with ourselves? Sometimes when we are going through emotional turmoil, we would like to hide ourselves from ourselves because we are not able to face ourselves or things like that. When you want to run away from ourselves, kind of a situation. So, but other than that, privacy is always with the external world, not within ourselves. But people who watch us, we do not want them to watch for two reasons. Maybe because we don't know them and they don't have any business to peep into our lives. But as a aside, I can say that most popular show of late is Big Boss, where we all enjoy watching somebody else's life. And then it's quite interesting that it's very high on the TRP ratings. If you look at who are the witnesses to our conduct, now when we speak about privacy, we are talking about people other than our own self or our soul or Atma, whichever way you would like to look at it. The witnesses are earth, the Panchabhutas as they are referred to, our understanding, which is Atma, day, night, and the conduct of all living beings is all times watched by these elements of nature, including ourselves. This sloka is in the context of the Mahabharata, where the question posed to Bhishma Pitama, who was on the bed of arrows by Yudhishthira. He questions Bhishma Pitama in the context of how does one explain the karma philosophy, which is the core of the Sanatan Dharma, that even after death, your good and bad activities or the consequences of your good or bad karma will follow you into your next life. It is in this context that Bhishma Pitamaha quotes this sloka from Brihaspati, who's considered one of the greatest rishis who's understood dharma. So he, in this sloka, explains as to how karma follows a person even after the body and the soul are separated by an event called death. It is therefore that a dharma, which is follows the person's soul or atma even after death, and therefore the next birth he continues with the prarabdha karma as they refer to, which is born at the time of the birth of the child itself with him, and then he lives through or goes through the prarabdha that is acquired as an inheritance from his past life, be that as it may. So therefore the concept of witnesses to our conduct, other than anybody that who's physically watching us in the sense of being a witness in the legal sense, or others who watch us or hear us or snoop over us, is something which is in the social realm. This sloka is relevant in the spiritual or the philosophical sense of witnesses to our own good and bad actions. But now, in the sense of social media giants who are having access to our personal lives and our activities, it becomes relevant to see what exactly are they doing. Can we have to the next slide? See, I mean, if all of us are familiar with this user agreements when we download a new app, but if anyone has checked as to how many words constitute these terms and agreements, and then it is a very illustrative number, it could be less or more. I mean, but indicatively, the effort that my colleagues have put in to figure out how many words do these individual agreements constitute. The Facebook group of companies, which includes Insta and WhatsApp, their terms and conditions, which are not in one place, but they ask you to refer to another document located at another place, together would lead to a 14,000 words of a document that you're expected to read and understand before you accept and download the particular app. And then by downloading, after pressing the accept button, you are actually agreeing to a particular arrangement or a contract with them. Similarly, Google has about 5,500 words lengthy document, which is the contract all of us have executed by using their software, because that is the precursor for you to have access to the world of Google. Similarly, Twitter has about 5,606 words of a user agreement, approximately, as I said earlier, which is what you have to agree before you can actually access or you can actually use their services. I mean, that's the kind of word count that we are looking at. Here, probably we need to bear in mind that are we as users, what is it that our dual relationship with these social media giants are like? Are they any kind of favors that these giants are doing to us? Or is there a contract that we are actually unconsciously or consciously or unknowingly or knowingly engaging into, and then trading with them by bartering something? That is the critical part of this presentation that we would like to highlight as to what exactly is the consideration these giants are receiving from us. We all know that the services they provide to us are funded by the advertising, and they say that they don't sell our data. That's what they actually keep advertising. But if you look a little deeper, this is what you get to see. Can we move to the next? We're just having a small presentation issue because multiple slides are showing up. We're just rearranging the slide. Before Usha arranges the slideshow again, what I would like to highlight is that we are all familiar, as I understand that the group of audience is law students who are probably in the first, second, or higher classes of their law. So if you are familiar with the Contract Act, the Indian Contract Act of 1872 set down the law or the legal parameters for any individual to enter into a legally binding contract. The primary requirements are 2 consenting adults primarily for a binding contract. Here, the services are made available even to minors, be that as it may. The second part is that the contract should be for certain consideration, and then it should not be for certain unlawful or illegal purposes. So what it turns out is that if a consideration is flowing from one to the other, the consideration should be legal. It cannot be an illegal consideration. The object of the contract should also be legal, and it cannot be against public policy, because contracts contrary to public policy will be void under Section 23 of the Contract Act. So here we have a person to an offer, an acceptance, a consideration. And then the most important aspect of a contract is consensus ad idem. Now, do we have a consensus ad idem when we enter into a contract, not knowing really what we have contracted? So that's the critical part of a contract. When we enter into a social media contract, are we aware of the terms and conditions and or the waivers that they've obtained from us by click of an agree button when we activate the particular service on our digital device? As I indicated, the number of words which are going into these particular contracts is phenomenal. Can someone confirm if the presentation is visible?
No, sir.
Oh, it's not yet visible. Yeah, now
it's visible.
Yes. Yeah, now you can get into the presentation mode. Yes. Now, if you see the first slide, I mean, I will not read it. I mean, you can just look at the number of things that they have taken from us. This is the Facebook group of companies. They are actually taking from us the information which is displayed. To wit, you are looking at what? I mean, you're looking at actually the pages the consumers liked and follow, accounts, hashtags. I'm sorry. And then you are actually having the entire activity. I mean, if you just read the people or accounts you interact with, the time frequency and the duration of your activities, payment information, such as your credit or debit card number and other card information, other account and authentication information, billing, shipping and contact details, unique identifiers, device IDs, and other identifiers such as from games, apps, or accounts you use, the family device IDs, about nearby Wi-Fi access points, beacons and cell towers, access to your GPS location, camera or photos, the name of your mobile operator or ISP, language, time, zone, mobile phone number, IP address, connection speed, and in some cases, information about other devices that are nearby or on your network. I mean, I would wonder, would any close family member would actually know any of this information? Or would we consciously agree for any of our own close blood relationships or trusted family members or friends or guardians would be given access to this kind of an information is something we all need to ponder. We really think that we have some private space at home. Please don't disturb me. It's my private space, or you can't access my mobile, or you can't check what I'm browsing, with whom am I chatting. These are the kind of small circles that we draw around ourselves within our social relationships. Now, let's look at what Google has to take from us. Google takes your name, password, phone number, email address, photos, videos, and we save information about the devices, the applications, access to Google services, collects unique identifiers, device types, operating system, mobile network, IP address, date, time, and blah, blah, blah. Just look at the length of this sentence where we try to get a gist of what they have said in those 5,500 words. This is the information that we actually are parting with Google. I mean, Google, though, was an internet browser. We had a debate when we were preparing this presentation, should we include Google or not? Then we realized that Blogspot and other social media platforms and blogging sites are all hosted on Google. So without access to a Google account or a Google registered account, you would not be able to access many of the social media platforms, and therefore we had to include Google also as a part of a social media giant, for the reason that your Google Maps is something we all live with, and we cannot live without, in fact, at this time, place. So Google Map exactly knows where you go, when you go, and if you connected your air tickets or anything with your Gmail, then it'll tell you when it's time to leave for the airport as well, and it'll ask you if you want a Uber, and then they'll definitely enable you with the services if required. So looking at that kind of bandwidth that they are having and the information that they are capturing from us. See, I mean, the duration of calls, routing information, types of calls, including videos the consumers watch. See, I mean, you could be in an incognito mode. I mean, you want to watch something in private, probably because you don't want to be branded either as a left or a right. So you would, but still be curious to know what the perspective of that version is. So we may choose to be in an incognito mode. Still, Google would know what exactly you're watching. Voices and audio information, nearby cell tower, Bluetooth enabled devices, Wi Fi access points, local storage server, logs, pixel tags, cookies, even the activity on the third party sites and applications that uses the service providers. I mean, so it's amazing amount of data which is being collected. Now we'll go to the next big platform, which is Twitter. This is again about 5,600 words, summarized into these few things. Display name, username, password, an email address or phone number. Service providers also collect payment info, consumers' credit card or debit card, card expiration, CVV code, billing address, cookies, IP address, location, contact list, operating system, pages, visited, device information, including applications IDs, and search terms if provided. So, I mean, it look at these the expanse of the information that they've taken. And if you treat this information which belongs to us as consumers individually, and this information is being bartered by us by pressing that accept button. So therefore, I really ask myself, was there any consensus ad item at all when these agreements are being accepted online? They encourage us to tick that box, scroll down sometimes in a very micro font terms and conditions, which are not legible and which are definitely not easy to read. I mean, therefore, it's very clear that they do not want to come out transparently about the information they are taking up. I mean, just imagine you would have seen the promotions of any new social network when they launch themselves. And if you've not seen that, probably you need to go back and see when they launch these services, what is it that they actually promoted and why did they encourage people to get onto these platforms? Are these information being provided upfront before they actually promote a product? Or that's the business part of it? See, ultimately, if these technology giants are the biggest capitalized companies in the world today, on the strength of the data provided by volunteering individuals across the globe. Now, when we volunteer our information, are we conscious about the information we seek to give? I mean, I keep asking myself, would this information be made available to me if I ask my children to share any of those data? How much time have you been speaking on your phone? Who are you chatting with on your Instagram? And in fact, the typical reaction would be, they'll shut the laptop, it's none of your business. Please secure my privacy. So, I mean, if that is the environment that we are living in, and the trade-off that we are giving with unknown entities across the globe, then there is something which needs to be looked into. I'm not really trying to say that the social media platforms are villains. Sorry, no. They have actually done a great service to mankind, and they have actually enabled reach to the people who are otherwise outside the reach of the traditional governments and the communication networks that the governments had at their disposal. So therefore, they've done human service to humanity at large. Now, but having said so, are they accountable for their conduct is the next question. Let's move to the next slide, please. Now, having seen the information that they have collected from us, let's see what is the information that they are sharing. Instagram can share the information to third-party applications, websites, or other services. Facebook and Instagram share infrastructure systems and technology with other Facebook companies. Instagram shares the information globally, both internally within the Facebook companies and externally with our partners and with those they connect and share with around the world in accordance with this policy. Consumers' information may, for example, be transferred or transmitted to or stored and processed in the United States or other countries outside of where the consumer live for the purposes as described in this policy. These data transfers are necessary to provide the services set forth in the Facebook terms and Instagram terms and to globally operate and provide our products to you. Now, therefore, I mean, my intern who actually done this spends more time on Instagram, so she's focused on that, realizing that probably this is what she's got into. But that seems to be true for all, because if you are part of the Facebook family, they actually bring you into a joint family. I mean, we have moved away from joint families, but the technology giants are bringing back the good concept of the joint family with the ill effects of data exchange without our knowledge. I mean, India as a society is always known to be a society which is completely an antithesis for anything called privacy, because the community lives that we live effectively, probably more than anything we would like to share with anybody, the family or the mohalla would know those things about us. And in fact, the things we think is not known to anyone beyond your immediate family are subject of discussions when you meet strangers. So that's the kind of environment socially that we have used to live in India traditionally. Now look at the kind of data sharing that this joint family, the technology families are doing within their extended families. And then probably they must be talking to each other and sharing with each other the information. So therefore, they're no different like the gossiping elders in the family or elders in the village, that they keep sharing information and then they enjoy the data, and they call it mega data and metadata, and they use algorithms to spread the data. And then we're used to how rumors are spread even before technology was there, and how word spreads even when there was no technology across the country. Now, with this power that these technology companies are having, they've actually structured this kind of information dissemination, and the technology is always neutral. The use to which it is put is what determines whether it is good or bad. So one actually cannot be sure if a particular technology is only doing harm or only doing good. It is dependent on how it is put to use and the people who are in control of these technologies. So it's like the nuclear button. Depending on who is in control of the nuclear button, the world feels safe or unsafe. The next 1 week, probably the world would still be not sure, because some people have expressed that there could be some escalation before the transition happens in capital. So these kind of apprehensions are there because of the individual personalities in question. So that is what makes the information being available in the hands of individuals or these social media giants potentially dangerous for everyone across the globe, unless there are measures and then there are checks and balances. Now let's see what Twitter does. Sorry, this is Google. Google shares the consumer personal information to their affiliates, the entity that belongs to Google group of companies, including those companies that provide consumer service, the European Union, such as Google Austria, Google Belgium, Google Israel, Google Spain, and other trusted businesses or persons it for them. So they are processing this information for others. So therefore, if somebody in Australia, let's say in Switzerland, would like to know the taste of Indian Swiss chocolates, so Google would actually capture the data on the basis of what you're purchasing, probably on your Googling or you're actually searching, and then it provides that data, and that data is used by business entities to actually create products to meet your particular requirements. That's really a bona fide use of data. Now, but again, as I said, the data in the hands of people who may not be all that business minded, and they have other ulterior or extraneous reasons to alter or manipulate data, then there is a problem, and that the information is there with them, as we see. Then let's look at the next Twitter. I mean, Twitter shares consumers' personal data with consumers' consent when the consumer authorizes a third-party web client or application to access their account. So therefore, if you're tagging or connecting different business accounts so that you get their feed, etc., then you are actually authorizing the exchange of data. And then the data doesn't stop with what you post on your Twitter. It goes beyond. So whatever you're linked to is actually being taken. Twitter may share the consumer's personal data, payment information with the service provider, which engage them to provide third-party services such as Google Analytics. So therefore, Twitter and Google seem to be having an arrangement already where the analytics is being done with Google Analytics, and they are going to process and then give information and then draw inferences. And then this big time what you call wealth creation for these big companies, because data, as they used to say, is oil, but now it's become something more than oil. Data is the new oil is the word coined a few years ago. But I think we are going beyond that. Data seems to be the nuclear energy that has come about. which can be used for good and which can be used to destroy. That's the power that this data has today. Let's move to the next slide, please. Now, having said what the data can do, now let's look at the existing legal framework. I mean, there's no point fretting that, oh my God, I've actually contracted with them and I'm using those services. I am personally not really worried because I have a few services which are enabled on my devices, and then my family and we are all using it, and I'm not really fretting for it because I know that the legal framework that India has may not be very expeditious, but it is definitely effective. It may be time consuming, but it is time tested. That's my experience as a practicing lawyer. Now, if you look at the Contract Act 1872, the Contract Act binds any dual contractual relationship between parties. Now, as I said, there should be two parties, there should be an agreement, there should be a consensus ad idem, there should be consideration. Consideration can be in kind. In this case, we have taken a lot of waivers from us and consents. So therefore, through that, they are providing us services. So therefore, there is a contract which is there between us and the social media giants. And in some of the contracts that we examined, the user agreements, they have conceded the jurisdiction and they are actually participating in proceedings initiated against all these named social media giants, and they are responsibly addressing the concerns of the citizen when they are hauled up before courts, and they are facing the judicial review on their actions on the legally permissible parameters. And they are entitled to take defenses, including the defense that the courts do not have jurisdiction. But be that as it may, but they are there before the courts. So you could enforce any breach of your rights as being a right which has been traded without a consensus ad idem, because I really did not know what you have taken from me. I've only subscribed probably for a WhatsApp services, or let's say a Facebook, a social network services, but that does not authorize you to take something from me. The next act that I've listed is the Copyright Act. Some of you may be familiar with the Copyright Act, and some of you will be knowing about it in a matter of time. The creator of content is the real owner of the copyright, unless there are certain statutorily recognized exceptions to that. So therefore, if I take a picture, whether it is good or bad, I am as good as Raja Ravi Verma as far as my picture is concerned. So therefore, I own that picture. Nobody has a right over it. And they seem to be taking license from us for the pictures that we are uploading on their website. So therefore, they are actually entering into a relationship which is also recognized under the Copyright Act, because the post, the content that we create, what we write, is all a subject of copyright. And registration is not necessary, because the creation is the act of creation of a right or a proprietary right as an intellectual property right. And therefore, there is a right which is coming into existence qua the property that we have generated and then posted or shared on a social media. They take license to use that. So normally, if you were to take a subscription from Microsoft, you would only get a license to use it on your laptop or the number of devices they authorize. That's what you get. They are taking a similar license copyright from us. So, I mean, therefore, it is actually a barter kind of an arrangement where we download and access their software and we upload our content and give them license to use it. Then, of course, the Constitution of India comes in the center of everything. So, Article 14, 19, 21, and then the case Puttaswamy judgment has actually set out that privacy is an aspect which runs through Part 3 fundamental rights in different aspects. So therefore, fundamental rights, Part 3, completely take different aspects of the privacy. Right to life, liberty, and dignity are part of Article 21. Protection against any irrational, unreasonable behavior is under Article 14. And right to protect your own business interests and other commercial interests, which you may have invariably shared, is also part of your right to freedom of speech and business and expression. That these are the rights which are protected. And Article 300A expressly gives us a right to property. So the right to property is recognized under Copyright Act and the other intellectual property rights, and is constitutionally protected under Article 300. Now, when you look at our remedies, the remedies are available as consumers, because we are taking subscriptions and we are becoming consumers of these tech companies. So they are service providers and we are the consumers who are users of those technologies. The 2019 Consumer Protection Act, which replaced the 1986 Act, has introduced a definition for an unfair contract. An unfair contract in the plain meaning shows that there is something which is unequal in the relationship drawn in the agreement. If you look at these 5,500 words or 15,000 words of user agreements, you would find that the contracts are heavily loaded against the individuals, the users. There is a principle of contra profantem. In case a contract is ambiguous, it will be interpreted against the interest of the person who's in the dominant position and who's drawn this contract. So therefore, that proposition would come into aid in case of ambiguity. Other than that, we are all being consumers. We would have remedies under the Consumer Protection Act to protect ourselves against these unfair agreements. Recently, the Supreme Court, in the context of a developer agreement, has actually held and referred to the unfair contracts and the insertion of the definition of unfair contracts under the Consumer Protection Act 2019, because the developer agreements are the most one-sided agreements that India has seen for decades, where the big builders would be in a position to dominate and the individual part owners would not be having a bargain because of the smallness of the size and the strength of the builder. So those clauses which are found to be unfair, the courts have the power to not give effect to them in favor of the dominant party. So the unfair contract is a concept which is always recognized in India as a matter of public policy. And of course, most of you would be familiar with the Information Technology Act and the rules which are in detail dealing with various aspects of the rights for data, protection of data, and the roles of the intermediaries, social media companies, others who are having custody of these data. So therefore, I would not like to deliberate more on the Information Technology Act and rules, because that is one of the favorite subjects of your generation, and you would have all done probably enough reading on that. Then going back to the Indian Penal Code, this is an 1860 code. Now, I find that whenever there is a crime in the society, there's a hue and cry for new laws. I mean, I have been a very strong believer that the existing laws, if effectively implemented, we don't really need new laws. Most of the offenses which are made in the digital world are mirror images of the offenses in the real world, because the platform of the offense is changed, but the offense remains. So if somebody is publishing in a print media an article defamating somebody, there is a defamation law in place which takes the defamation to the doorstep of the publisher and the content provider who's the defamer. Similarly, the defamatory articles being hosted by social media network, and then I've argued it, and Supreme Court has accepted my contention in the case filed by my clients, Visakha Industries, who hauled up Google for hosting a blogspot where defamatory articles were being posted in the blogspot owned by Google. The question there was whether the intermediary is protected under the rules, etc. or not. This complaint had arisen sometime in 2008 when the law was quite nascent. Be that as it may, the judgment which has come in subsequently, the court has looked at certain elementary ingredients of an offense under the IPC. If those ingredients are made out, then the accused would have to face a trial, and it will be a matter of evidence whether those ingredients are actually made out on the facts of the conduct of the technology companies or not. And Google is in fact facing a criminal trial in this regard. I mean, subsequent to the Supreme Court judgment. I do not really know the current status of the trial. But the fact remains that if we bring these social media companies to answer any violation of any Indian laws, Indian law would also have your public policy as an overarching moral or the social order that the society and the courts acknowledge and act upon. The overarching public policy is in fact defined through various enactments where the legislature sets out certain social order and socially accepted behavior, and the breach of which is considered to be unconscionable, and it can be treated as against the public policy of the country. So once you can establish that certain kind of a behavior is contrary to public policy, which is in violation of any established law, or if it is unconscionable and so immoral, then Section 23 of the Contract Act itself becomes the fallback provision to say that the contract where I've agreed to share the data, but if you're using it for immoral purposes, illegal purposes, and then you're trying to unfairly deal with me on the basis of an unfair contract, then I have a remedy in contract law and I have a remedy before a consumer forum. Similarly, the Competition Act comes in. The dominant position of these players are also being questioned in a different context because it's a specialized enactment. You need to fit into the specific requirements, which are the jurisdictional facts before which the jurisdiction of the Competition Act authorities get triggered. But the legislative framework existing in the country, to me, is adequate and is actually sufficient to bring these large giants to answer before a court of law in India. And that, I think, is the strength of our Indian democracy and the judicial system. The fact that they are actually facing trial and they are actually answering is a matter of reality today. So the WhatsApp trying to change its policy for India and then deferring it is also a proof of the fact that they've realized that India is too big a market, that they can't play around and treat us like the natives, which probably the East India Company or the invaders before treated us like, and then only to be plundered and looted. Now they realize that India is a country which is leading the information technology revolution. There is a lot of awareness. The literacy in India, in the traditional terms of being able to read and write, may not be at par with the Western world. But the knowledge society that India has, where people are conscious of their rights, they actually assert their rights and their opinions are actually expressed loudly. And that is being heard. And that is evident from the reaction of WhatsApp that they have actually deferred to extend the new policies because the migration into Signal or Telegram or any other platform that Indians have chosen to. So therefore, it is a case where we are equal partners in this technology revolution. We are equal stakeholders and we are not remediless. That's the message that probably I have on this. Let's go to the remaining slides. These are the judgments I had referred to. Justice K.S. Pottaswamy, 2017, 10 SEC 1. Shreya Singhal is where the freedom of speech was kept higher on pedestal. And then the state's power to control the intermediaries or to direct or arrest people for expressing free speech. Now, the reason I quoted this judgment, it's quite some time. We've come a full circle in life, judicially, where the judiciary stood up and then questioned the state action when free speech was being aired on social media, to where cognizance is being taken for contempt on social media. So therefore, we have come a full circle where we've seen the benefits of free speech and we're also seeing the venomous hate and then animosity which is being spread on the social media, which needs to be booked in the existing legal framework. So contempt of court for the judiciary, but other citizens and individuals still have their remedies under your defamation laws, your damages suits, and also injunction suits are available. Apart from any breach of data or violation of your data in contravention of any moral rights that you have on them, I think you have remedies even before the Consumer Protection Act. Google India is the case where I've referred to. It was a judgment delivered in 2020. And then Google is asked to face a criminal trial for as an intermediary to enable a blogspot where a person tried to defame a publicly listed company. So the question is, how is the intermediary responsible? The intermediary is responsible for me, because that issue has not been decided there. But for me, I firmly believe that if somebody is providing a platform, a private entity, which is making money out of it, and it chooses to be a judge, I use the word judge, because if somebody says post something and it is not defamatory, but it is free speech, then somebody else is aggrieved that that's free speech and says this is defamatory. If you choose not to act upon it on your own volition, then you're taking sides invariably. And if you've chosen to take a side and that the defamatory material continues on your blogspot, then you are answerable in law as an abettor. Till the time this is brought to your notice, you are an innocent intermediary. But the moment it's brought to your notice, your terms of use, I don't know how many of you are familiar, the terms of use of most of the social media platforms bar defamatory material. They bar child pornography. So therefore, they are well within their contractual rights with those publishers, namely the people who are expressing themselves or exercising their rights of free speech, to withhold those material because somebody else is complaining. As long as nobody is complaining, they are free to host it. But the moment there is a complaint, you can't act as judge and you can delay it because the damage to the individual who's at the receiving end of the defamatory content is irreparable. And then you become a participant in the crime. So you're no different than an abettor in the normal sense of an abetment of an offense, or probably trying to aid an offender in hiding or not coming forth by not disclosing their identity. But there are procedural safeguards that these technology companies have been provided, and rightly so that they don't get harassed, because most of them operate on algorithms and there is no human interface. But definitely there should be a mechanism for remedy. Otherwise, you become a party to the entire defamatory activities. The third judgment that you're looking at is, I think it should be number 4. Somehow it's number 3. The second category of judgments probably. Irio Grace Realtek Private Limited. This is a recent judgment of the Supreme Court. Justice Indu Malhotra has elaborately dealt with the development agreement and referred to the new provisions under the Consumer Protection Act 2019, where unfair contracts have been held to be against public policy. Pausing here, I could also take you to the Arbitration and Conciliation Act. Any arbitral award in India has been recognized to be subjected to a judicial review under Section 34. And one of the grounds for a judicial review where the award can be set aside if the award is against the public policy of the land. So the public policy of the we can refer to the Contract Act, the various legislation under the Indian Constitution, which declares certain activities or certain conduct as against public policy. Anything which is declared an offense is against public policy. Anything which is subjected to certain restrictions or licenses, then that indicates the public policy on that subject. So therefore, public policy is so sacrosanct that an award by an arbitrator can be set aside if that award is contrary to public policy. So that is the high pedestal that public policy has been provided under the Indian legislative scheme. So being a society which is governed by rule of law, we are actually in a space where there is a lot of legal and statutory protection already available to us. So I keep hearing about lack of an appropriate or a complete data protection law in the land. Maybe it is required, it is desired, but nevertheless, the existing framework, according to me, is definitely available and is definitely effective. It may not be smooth and quick, but they are very effective remedies, because once the person is called into a court, the decision may get delayed. But once he is made to answer, they realize the cost of such mistake that they would have committed, and then they are definitely going to course correct. And then most of the technology companies are not into getting into interstate disputes between the users. So they would probably evolve more robust mechanisms that they will say that your free speech ends when somebody else's right to reputation begins. And that's probably how it should be. And there should be neutral platforms. So you can only post something which is not offensive, and your free speech cannot be at the cost of somebody's dignity or self-respect. That's the way I think the technologies companies need to look at it. Otherwise, they will be, of course, I mean, it's a good thing for us that the technology companies get into more litigation, then there'll be more work for the lawyers and the law interns and the future lawyers that we all are looking at. Probably you can go to the next slide, please. So now, I mean, I related the sloka from Mahabharata, where who are the witnesses? The earth, wind, ether, water, light, mind, Yama, namely the power to punish, understanding, Atma, day, night, all together witness the conduct of all living beings at all times. With these, dharma follows the creatures after death. That's what Brihaspati had said. Now, in addition to all this, they all will continue, whether we have power, whether we have internet or not. They've always existed for thousands of years. In addition, what we've added to our witness list is probably Facebook, Google, Twitter, WhatsApp. Maybe I've missed out on Amazon, Flipkart. It really knows what exactly you do. And probably the movies that were named, I Know What You Did Last Summer, probably were prophetic for these technology companies. They would have sponsored them because they exactly know what you did last year. Because when I suddenly open the mobile phone in the morning, it shows me what I did last year. It shows those pictures. I mean, therefore, they are having this kind of power over us, and they're witnessing things. And of course, they won't let you forget. If you want to forget certain things of the past, unfortunately, these technology companies do not have the human intelligence. Are they not sensitive? So they would still show up pictures which may hurt us. So that's the kind of space that we are living in. Therefore, I find that data probably is no longer new oil. Data is nuclear or something as powerful as the nuclear energy, and depending on how we put it to use. If it is in good hands, we are safe. If it is in bad hands, God bless. That's the way it is. Thank you. And I would like to acknowledge the contributions of Shivani Chaudhary, an intern from Think India, Usha Sri Gavaraju, who's helping me with this presentation, and Shivani Tushi, both, and that's the woman power that made this presentation possible. Thank you.
Thank you, sir, for sharing such great insights with us. And I can totally say that the session was quite informative. One, you touched upon all the aspects that dealt with these technological giants and how they use our data, how they breach our privacy. But I have one question in my mind. Like it is related to the IT Act. Basically, if we go through the IT Act, there is Section 79, which provides an exemption to the intermediaries in certain cases when they breach our data. So don't you think when intermediaries are there in between in the whole system where our data is being breached or there is any other privacy threat to our data, then intermediaries should be held liable? Why are there exemptions for the intermediaries? Like also that's a loophole in our IT Act because intermediaries like Facebook, WhatsApp, they often use this section as the tool to escape from all these data leak scams and all such things. Want to share some light on this?
Yeah, I mean, Section 79 is what was interpreted by Supreme Court in Google. Google was made to face a criminal trial. They also took this defense of an intermediary. It's actually putting the intermediary defense to test in a court of law. I mean, any defense available to any person who's charged of any offense is available to them only in a court of law. Until you bring them to a court of law, it is not a blanket immunity that they are not even answerable. See, ultimately, it is the court which will decide whether they are within the defense or they are outside the parameters of defense recognized in law. See, there are several defenses available even under the Indian Penal Code. Unsoundness of mind is one. But does it mean that the investigating officer would exercise his discretion and not even initiate proceedings, not lodge an FIR? I don't think so. An FIR would be lodged. A grave and sudden provocation is a valid defense where you could even go to the extent of causing death of a person when there is a threat of an imminent threat of death to person and property, or probably any other things which are recognized, an affront to a woman or things like that. So therefore, the person is definitely brought before law, and it is for the courts to adjudicate if that defense is valid and whether the portion of defense was justified or not. There you are well within your rights to say that the defense provided to them is still that point when I did not raise my concern. Once I raise my concern, your status as an intermediary is altered to that of an abettor because you choose to take the side of one person who's, according to me, a violator of my rights and therefore also in breach of law. So once you, and this is a continuing offense as I see, the offense on social media platforms or digital platforms are a continuing offense. Every day that it continues to be hosted on a server, which is accessible to participants across the globe, it is a continuing offense. The moment I put you on notice, we can give them a reasonable time to react. Once the reasonable time is over, let's say 48 hours or 72 hours or whatever time, maybe in a given case because of the volumes of data that they are dealing. But if they choose to act and then respond saying that, sorry, unless you go to court, we are not going to take it off. Your remedy will be either asking for a take them off, or you can actually say that, boss, now I treat you as a participant in the offense. Because abetment is a recognized offense under the Indian Penal Code, isn't it? You may not have conspired to commit an offense, but the continuation of an offense is not possible without your active participation in providing your platform and in making it available for new users who have come to know about it or were able to access it after I have raised a flag of concern. That's where your remedies are. And therefore, this is not a blanket defense. Like any other defense, the defense will be only available before a court of law. They cannot even see, but at that stage, we need to assess whether their participation is active or are they willing to take down? And therefore, they need to be more sensitive. If they are not sensitive, for me, anybody who's actually harming my reputation and somebody is enabling it in spite of being put to notice, for me is no different. And in fact, he is actually enabling the commission of offense or continuance of the offense. That's the way I approach it.
Thank you, sir. I totally believe what you said, and your answer was quite an enriching one. And plus, there's one more question about this. Like, since there are continuous privacy threats to our data, like most of the people are shifting to Signal due to this WhatsApp privacy issue. But do you think that that this will change the whole scenario, or are there any other way ahead to take a stand on this issue that India should adopt to? Like there should be some amendments in our law, like in the Information Technology Act, because that's the main act that regulates the whole cyber law.
See, what happens is when technology is growing at the pace at which it is, in fact, the Information Technology Act is of 2000 and 2020, substantial amendments have been made. Sometimes the society cannot actually catch up with the growth of technology or science. So it takes time. Then the principles evolve over a period of time. Therefore, it is always better that we don't really get carried away by the framework of technology or the platforms on which we are dealing. If you look at it from a perspective of a real life in a real world, if these were offenses, the offenses are those which are defined and made offenses in law. Otherwise, there is no offense at all. So, therefore, when you talk about theft of data, whether you had any proprietary right which could have been subject of theft is a question. Your intellectual property rights regime is already in place, and this has been recognized in jurisdictions across the world. So therefore, if you claim a copyright breach, and the license is the defense that they can have. So your data is something you traded without a consensus. Therefore, the contract is void. If there was no consensus ad item, the principle of contract law is that there should be consensus ad item. In the absence of consensus ad item, there is no contract enforceable. So therefore, where is the question of passing of a title in a proprietary data from one to the other in a void contract? Therefore, the restitution provisions come in. The Contract Act says that if somebody has received something in the absence of a contract, then he is liable to restitute it. So he cannot retain it, those benefits. Either he gets into a legally binding contract where there is consensus ad item and the contract is not unfair. Because Indian law as in 2019, see, therefore we need to look at the Indian legal ecosystem holistically and not look at it from a myopic perspective of the Information Technology Act. Information Technology Act has its purpose, but it doesn't really take away the other public policy which is available through different legislations. Therefore, I would look at it from a perspective as if, I would give you a different metaphor. Assuming we did not have the weaponry that we have, we still went to war with China in 1962. We didn't stop. We didn't let them walk in. Even when Galwan Valley happened, the Rafales were not here, but we still stood up and fought them, isn't it? With whatever weaponry we have. So we have enough equipment and weaponry at disposal. And then, of course, a GDPR equivalent data protection law or a robust omnibus umbrella legislation which takes care of all these things would be welcome. But until that Godot comes home, we cannot sit idle and think that we are unprotected. That's the purpose why I've drawn attention to the other provisions of law.
Thank you, sir. The session was quite an informative one. You really touched upon all the issues related with this theme, and we would really like further engage with with Think India on more talks. And really thank you.
Thank you.
Thank you to all the attendees as well for taking out time out of their busy schedules.